My name is Kristen Menke, and I'm Special Master for the Fourth Circuit Court here in Davidson County, Tennessee. A Special Master is an individual or attorney appointed by the court to provide certain services and perform judicial and quasi-judicial functions at the request of the court or by order of the court. There are a lot of jobs for a Special Master, but the one I'm going to talk about today is judicial settlement conferences. Judicial settlement conferences are mandatory settlement conferences conducted in all contested cases. They are facilitated by myself as the Special Master, and I serve as a neutral facilitator to try to help parties reach settlement or settle some or all issues outside of a full trial. This is cost-effective, time-efficient, and it removes the uncertainty of a trial by allowing parties to make a decision for themselves. The Fourth Circuit Court schedules judicial settlement conferences for all contested cases, and those conferences are scheduled at the same time that the trial date is scheduled. The dates are given out by Ms. Ronell Griffin, and once scheduled, they become part of a court order, and attendance at the settlement conference is mandatory. All parties, whether represented or unrepresented, are required to attend the settlement conference, and attorneys representing parties in a divorce proceeding are required to attend the settlement conference. No other parties are invited to attend. There are no friends, family, ex-boyfriends, new boyfriends. There's nobody else that should attend the conference unless it is an expert that is there on a particular topic or issue related to the settlement conference. Once the conference is scheduled, you have advance notice of that, and about 72 hours prior to the conference, parties are asked to send to the Special Master, me, a confidential statement pertaining to all issues or all matters that will be at issue at trial. So that could be children, child support, alimony, asset division, debt division, whatever it is. That statement is provided directly to me. It is not filed with the clerk's office, and it is not provided to the other party or counsel for the other party if they're represented. It's not always necessary that you provide a lengthy multi-page document for me to review prior to the proceeding. It's helpful to me just to have a joint asset and liability statement, any sort of chart that's showing me a proposed division of assets and debts, and certainly if there are children involved, your parenting plan, anything that you are going to use at trial that is relevant to your side of the case is relevant and helpful in a judicial settlement conference. So providing as much of that at the conference to help facilitate those discussions is helpful to me and helpful to you, again, being able to reach an agreement outside of a full trial. On the date of the Judicial Settlement Conference, we begin promptly at 9, so that means you need to be here prior to 9 o'clock. And we always warn people that traffic is difficult, parking is difficult, everything takes longer than you think it will, so please plan accordingly. I don't take an official lunch break during the Judicial Settlement Conference, so it's good to plan to order in lunch, bring snacks, drinks, whatever you think you might need to be comfortable for the day. It's also often very cold in the building, so it's good to bring extra layers so that you're, again, comfortable while you're here and have everything you need to be able to make decisions and participate. Settlement conference participants are required to be here from 9 o'clock until 4:30. Again, this is a court order, and so we will go until meaningful negotiations are no longer happening, but it is not a situation where you get up and walk out of the settlement conference because you're unhappy with how things are proceeding. You are here and attending the conference until released by the Special Master of the court. As I mentioned, the day starts at 9. Usually we work out of one room, so I'll bring in the plaintiff, and if they're represented, their attorney first. I'll start with them and then swap out and bring in the defendant and their attorney if they're represented second, and we'll shuttle in and out of the room, alternating between parties until a settlement is reached, or, as I said, settlement negotiations are no longer productive. It's advisable to bring a laptop computer or to send documents to me in advance of the judicial settlement conference so that we have existing documents to work from. I can't draft everything and do the settlement conference at the same time, nor am I supposed to do that. So it's suggested and really is part of our chamber rules that you bring something to draft with, and also that you provide those Word documents to me prior to the date of the hearing. Judicial settlement conferences are confidential, and that means no information provided to the special master, to the other party, or to any attorney during the judicial settlement conferences will be provided to any other third party outside of the conference, and this includes the judge. Information is also confidential between rooms, and so if at any time during the conference you do not want me to share something with the other party, you just need to let me know that, and I'll adhere to your request for confidentiality, and that information will not be shared. I mentioned earlier that this is a court order, and so all judicial settlement conferences are subject to the court's discretion as to whether they can be canceled, continued, not occur at all, whatever the case may be. And that means in order to do any of those things, you must have the court's permission. I do not have the ability to cancel, waive, or otherwise reschedule a judicial settlement conference. That must come from the court. So if you find yourself in that situation, you need to reach out to the court as soon as possible or file the appropriate pleading to make sure that you get the relief, or at least try to get the relief you're requesting. I hope all of this information has been helpful to you in learning about judicial settlement conferences. As always, you can look to our chamber rules for further guidance and more information on judicial settlement conferences, as well as any other topic that is covered there and hopefully helpful to you in being in the Fourth Circuit Court.